5 second. Start. As there is a need to protect our judiciary, YSRCP supports this amendment bill. The union government proved again that they are amending bills on temporary basis. There is a need for comprehensive reforms in our judiciary. We are still following laws made during Britishers' regime. We need to analyze and review those laws. Sir, we know that justice delayed is justice denied, which means that if there is any delay in delivery of justice, it is like denying justice. Our country stands at number 2 in population, and there are large numbers of married people in our country. Also, there are several cases of divorce as well in our country. As per a survey, 1% of married people are seeking divorce. In metropolitan cities, it is 5% of married people who are opting for divorce. In their mechanical life, divorce has become an unavoidable outcome. There are many who are living separately as they cannot go to courts. At the same time, pending cases are a big challenge to our judiciary. We should not forget that this is our responsibility to find a solution to this problem. If we look at the number of pending cases, we have 4.7 crore pending cases in our country. In Supreme Court, there are 70,000 pending cases. In 716 family courts, there are more than 12 lakh cases that are pending. As per surveys, 15% of our population is suffering from mental disorders, and around 35% of our population stated that they are not happy. There could be many reasons. Shortcomings and flaws of our family system is also one reason for this unhappiness. It is the responsibility of the government to ensure happiness all around. Therefore, government should amend laws for the well-being of people. India stands at 143 in World Happiness Index. Though we claim that we are the largest democracy, government should be aware that people in our country are not happy. Similarly, in judicial services, we are not even providing 10% opportunities to weaker and backward classes. Women representation is also quite meager. Judges are being appointed by the courts. Legislative bodies do not have any powers in this matter. Accountability of courts is a question mark. I request the government that this is the right time to overhaul our judiciary. When we brought family courts bill in 1984, we had these principal goals. First, disputes should be settled through reconciliation. Second, cost effective justice for people. Third, timely delivery of justice. But even after 38 years of bringing this law, we need to introspect whether we achieved those goals. Sir, after studying family courts in our country, I found 12 challenges before us. Counselors. Counselors change every 3 months. As a result, judgment is getting delayed. Family members' problems are getting aggravated. Especially women face difficulty to explain their problem to new counselors. Therefore, the government should take steps to appoint counselors on permanent basis. Similarly, family courts cannot stop domestic violence. Victims are often advised to file a case under domestic violence. Common people cannot file 2 3 cases for small problems, which will further aggravate their problems and weaken them financially. I request the government to note this difficulty of common man. As per Principal Law of Family Courts Bill 1984, more than 50% of judges should be women. I request Honorable Minister to state how many women judges are there in 716 family courts in our country. Fourth challenge is that there are different rules in different states. A person from UP is married to a woman in Maharashtra and they may be living in Assam. If they have a family dispute, where should they file a case? In Maharashtra, rules are different. In UP, they are different. And in Assam, also, there could be different rules. When these rules are not uniform, what rules should these aggrieved parties follow? I ask this question to the government. This law also ignored one important aspect: who will take responsibility of people. We have provision to resolve disputes between a husband and a wife in family courts, but children are subjected to immense stress. They are spoiling their life by visiting family courts. There is no such provision for children in family courts. Similarly, family also includes elderly parents. Whether this law provides any such relief to elderly parents. Therefore, I request Honorable Minister to look at this aspect as well. Most importantly, police do not come under the purview of family courts. In such scenario, who will implement judgment of a family court? On many occasions, settlements are being done in a dubious manner. Who is responsible for this? The main objective of these courts is to provide justice to common people on time with little expenditure. We should ponder whether we achieved this objective or not, as implementation by police is not under the purview of judges. We need to think about this. Regarding maintenance, if a family court judge awards an alimony, who is going to enforce that judgment? These are being left for many years and the women are suffering in absence of that alimony. Therefore, amendments should be made to give powers to the courts. If required, the assets of husband should be sold to provide alimony to the wife. Who are appointing judges of family courts? They are being appointed either from magistrate courts or subordinate courts. They do not have special training, therefore, they are functioning like a regular lawyer discharging regular cases. As a result, cases are getting delayed. I request that judges of family courts should be provided with special training so that these cases are discharged on time. As per this law, there is no role for lawyers in these courts. In special case, if judge permits, one can use services of lawyers in these courts. In such a scenario, how uneducated people will deal with their cases? Whether we are providing relevant information to public in all languages, whether we published any standard procedure. We should make available rules and regulations of family court in all Indian languages. Stop.